Hi class, my name is Briana Pulley and I'll be presenting Competency to Waive Counsel and Represent Oneself. This presentation introduces the legal and psychological foundations of competency to waive counsel and proceed pro se. We will examine the Dusky Standard, the functional abilities required for these decisions, and how courts and forensic evaluators approach them. Much of the conceptual framework comes from Melton et al. 2018, who emphasized competency as a functional context-specific construct. We will also be going over why this matters, the foundational standards, competency to waive counsel and represent oneself, why waiver and self-representation require more, a key case, practical challenges, mental illness and incompetence, standards, and the conclusion. The Sixth Amendment guarantees both the right to counsel and the right to reject counsel. These rights are fundamental, but exercising them, especially self-representation, can dramatically affect trial outcomes. Evaluating competency in these contexts are essential to protecting due process and ensuring defendants can meaningfully participate in their cases. In sum, competency to waive counsel and represent oneself emphasizes constitutional right to counsel, constitutional right to self-representation, that courts must ensure defendants are competent before allowing and decisions have major consequences and for fairness and justice. The foundational standard. Dusky established the baseline for competency in criminal cases. Importantly, the standard focuses on abilities and not the quality of decisions. Melton et al. 2018 emphasized that competency is functional. The question is whether the defendant can perform the task required and not whether they can make wise or self-protective choices. Therefore, competency requires factual understanding of proceedings, rational understanding of proceedings, and the ability to consult with counsel. Navigating competency. What does competency actually mean? Competency is defined as a functional, context-specific legal construct that refers to a defendant's present ability to perform the task required in a legal situation. Waiving counsel requires decisional competence. The defendant must appreciate what an attorney does, the risk of proceeding alone, and the procedural complexity of trial. In addition to that, according to the psychological evaluations for the court's handbook, self-representation demands significantly more than understanding of the trial. It requires executive functioning, organization, communication skills, and procedural knowledge. Attached to this slide is an example of the formal request required for a defendant to give up their right to an attorney and represent themselves. The term comes from Peretta v. California, 1975, where the U.S. Supreme Court affirmed that a defendant may choose self-representation as long as the decision is made knowingly, intelligently, and voluntarily. Here is some food for thought, a quote from Dusky versus United States, 1960. The test must be whether the defendant has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. Now moving on to why waiver and self-representation require more. According to Melton et al. 2018, competency is task-specific, waiving counsel requires meta-decisional insight, self-representation requires higher-order functioning, and these demands exceed basic trial competence. Our key case will be Indiana versus Edwards, 2008. Indiana versus Edwards is crucial because it acknowledges that self-representation is a distinct competency. The court recognized that Dusky's basic standard may be insufficient when a defendant must perform complex courtroom tasks. Practical challenges. Forensic evaluators must examine multiple domains of functioning. They assess cognitive abilities, decisional reasoning, communication skills, and the effects of mental illness. These evaluations should be more reliable and valid than any other types of forensic evaluations. A common perception is that mental illness equals incompetence. A defendant can have a serious mental illness and still meet competency standards. According to Melton et al., competency is about capacity and not judgment quality. Also, according to Melton et al., with a few exceptions, competence evaluations involve an assessment for the defendant's present behavior rather than the mental state at the time of offense. This brings us to one of our final questions. Is there one standard or multiple? The legal system often uses one standard, but psychological science supports multiple. Melton et al. Argues that competency should match the functional demands of the task. Indiana versus Edwards reflects this shift by allowing a higher standard for self-representation. Finally, here is a reflection question for you. Should competency to waive counsel require a higher standard than competency to stand trial, given the decisional complexity involved? Think about it. Should you need to find any of this information, here are my references with the links attached as well. And thank you for taking the time to watch my presentation. I hope you enjoyed. If you have any questions, my email is attached below.